at all, and we will hear from the appellant.
May it please the court. My name is Jeffrey Kuykendall, and I represent J. Kim Hatcher Insurance Agencies, Inc., while referred to as Hatcher. I'd like to reserve 8 minutes for rebuttal. I'll briefly go over the facts and procedural history that lead us here. This matter arises from a motion to dismiss. All of plaintiff Daniel Jones's well-pled factual allegations are taken as true at this time. According to plaintiff, an agent from Hatcher solicited him to purchase homeowners insurance through the Hatcher agency. In approximately 2016, an agent came to his house, took some pictures, had a conversation with him, and signed him up for a policy through Nationwide Insurance Company. Mr. Jones was unhappy with that policy for some unexplained reason. He went back to an old policy he had with the Farm Bureau. The following summer, in 2017, Hatcher agent again approached plaintiff about applying for insurance with GeoVera, a surplus lines carrier. According to plaintiff, the Hatcher agent represented that GeoVera policy would provide the same coverage he had, but at a lesser premium. According to plaintiff, he was informed that by the Hatcher agent that he needed to sign the application and pay the first payment to get coverage. Plaintiff claims he was presented with a single page with the signature line. The page, which can be seen on page 84 of the record, contains several important pieces of information. First, at the bottom, it notes that it's page 3 of 3. Second, under what's called the binder box, which is towards the top of that page, there's an electronic X placed saying coverage is not bound. Third, the signature of Mr. Jones and the Hatcher agent are included with the same date of August 18, 2017. And fourth, above the signature of Mr. Jones, who is identified as the applicant, is the following. Applicant's statement: I have read the above application and any attachments and declare that the information is true and complete. This information is being offered to the company as an inducement to issue the policy for which I am applying. Plaintiff alleges that the rest of the application, presumably pages 1 and 2, were not presented to plaintiff. Importantly, there is no allegation that plaintiff was prevented from receiving or reviewing the rest of the application. Plaintiff then alleged that he, quote, reasonably trusted that Hatcher had all the information sufficient to apply for the GeoVera insurance coverage, and that he, quote, trusted that Hatcher would accurately reflect its knowledge on the application. Plaintiff asserted Hatcher's agent incorrectly answered application questions relating to a pond or water on the property and the size of the property. That application was submitted to the insurer, after which GeoVera issued the plaintiff a homeowner's policy effective August 18, 2017 for 1 year. Plaintiff renewed that policy in August of 2018. In September of 2018, plaintiff's home was damaged by Hurricane Florence. GeoVera initially advised plaintiff that the damage to his home was covered under his policy. However, GeoVera ultimately canceled plaintiff's policy, advising that the application did not list the fact that the property was 5 acres and included a pond, which it determined were material misrepresentations that had GeoVera known of them, they would not have issued the policy.
I'm going to interrupt you because you're going somewhat in your time, and we have read the brief, so everything you've told us, we know. So let me ask you, this is what I'm struggling with most about the dissent in this case. So help me understand, just taking it away from this case, just understanding general tort law principles. Suppose that they're planning their wedding, they've hired a wedding planner who's going to go out and buy whatever it is, flowers or something, and so they say, they only take cash or checks, and we've got to make the payment today, or we're not going to be able to hire these folks. So the groom says, okay, here's a check. I'm filling it out to this vendor we're going to use. I'm signing it. I'm leaving the amount blank. Here's the check, wedding planner that I've hired to plan the wedding, handle all the wedding prep for me. Go get it done. The wedding planner goes out, and when making the payment, everything's fine with this vendor, but accidentally adds another zero on there. And then when the check gets cashed, they can't claw the money back. It's for some reason it's gone. So there's a negligence claim, by the bride and the groom against their wedding planner. And the wedding planner's argument is, well, but you were also negligent. You gave me a blank check. And that's the contributory negligence. What about that theory in your view? I assume you would agree with me that claim would fail, but why, under the theory that's articulated in the dissent here? Why is there no breach of a duty there?
Well, I think fundamentally a check and an application for insurance are two different things. The application for insurance identifies, I have read this and it is true. I think it goes to...
But that's not, let me stop you there. And that's not, though, that like I declare I've read it and it's true. That's not a legal declaration. So, for example, you couldn't use that in court by saying, look, under some sort of penalty of perjury or other way that we can say this is the truth. It's just as a matter of the contract between the carrier and the policyholder, you're making, as a matter of contract law, some assertions when you sign it. Isn't that what's happening there?
I think the way I think about it from a 30,000-foot level is when you have an application with a material misrepresentation in it, and the application involves both the applicant and the insured having some role in it, that there are three possibilities. Either the applicant is solely liable, the agent is solely liable, or they're both liable. And in this case, they have to plead facts indicating that the agent is solely liable. There may be questions here as to whether the insurance agent should have done their actions differently. The issue I have with the majority opinion is that their focus was almost entirely on the actions of the Hatcher agent and not on the applicant. When we're talking about contributory negligence...
But suppose that you said to your insurance agent, we've got to place this policy, we're about to go overseas, and so you have the authority to sign for me. Sign my name, and I'm giving you the authority. You could do that, couldn't you?
I think you could. I think you do have to. I'm not suggesting, Your Honor, that you ignore the circumstances of any given case. You absolutely do. I think you do have to look at the entirety of the case. When, one, there is no emergency here where this man has to sign this application because he's going to Europe or because the flowers have to be paid today with the check. There is no sense of an emergency or rush or anything of that nature. There is no indication that Mr. Jones could not have said, I'd like to see the rest of the policy, or I'm not going to sign this until I read it. If there are those kind of facts, or I don't know what the outcome becomes if it's the agent says, oh, I'll sign for you, you said I can sign it. If the allegation is I didn't tell you that, or I only told you you could sign under certain circumstances, we do have a jury question that we have to go to the jury about. But can it be negligent to say to someone, I agree to this, you sign it for me? Yes, you could be contributorily negligent for doing that.
Well, I think your friends can argue that's right. They could be. But that ultimately, this is such a fact-intensive question that you can never say, as a matter of law, the mere fact that you signed something that said, I've read it and you didn't read it, means it's contrib. Because what you need to know is your agent who's handling it for you. What is that relationship? And was it reasonable for you to say, I know my agent that I've hired and I'm paying to handle all this for me is going to get it right. And so I absolutely can, in a reasonable manner, sign right now, given the circumstances. And you can never figure that out until you resolve fact questions that require at least getting to summary judgment.
That's where I disagree. And I think that this court, the Supreme Court of North Carolina, has a 100-year history of finding a different way. That there is it starts with, one moment, the Hardin versus Liverpool versus London matter, which is 100 years ago, 1925. Goes to the Inman case versus Sovereign Camp. We go to the Thomas Yelverton, the Jones versus Home Security Life Insurance, and the Goodwin.
Sorry, but I have a question about some of those cases.
Yes.
When you look at them, so you're citing them for the proposition that essentially the applicant, when he signs, is charged with knowledge of whatever's on the application, right?
Absent fraud, yes, sir.
Right, absent fraud. But when you look at those cases, aren't they about whether the applicant is entitled to the insurance coverage? They're not about whether the applicant has a claim against the agent who made the false entries on the application.
I think, Your Honor, the posture of those cases may not have come up in that way, but the language this court uses that the applicant will not be heard to say, I didn't know what was in the application. It wasn't presented to me, or in one case where they said, I gave correct answers and the agent wrote it down incorrectly. Yes, that agent in that case was working for the insurance company, but it's the same principle where the liability was through that agent in that case to say, I gave you the correct information, you wrote it down wrong, and this court said, I'm sorry, you signed the application, you said it was correct, you're not going to be heard to say it, again, absent fraud. If there were indicia of fraud, we'd be in a different case.
But again, that's about whether the insurance company has to honor the policy. Can you point us to any cases where we've said there's no claim between the applicant and the agent?
Well, I think when that in, is it Goodwin? One moment, Your Honor. Inman in 1937. The insured alleged he made accurate answers in the application for the insurance with the agent who was working for the insurance company. I agree in this case, Hatcher was not working for the insurance company, but I'm not sure the legal principle is any different with the agent providing incorrect information. It would then be, as an agency theory, be imposed on the insurance company.
Just to try to clarify. So in Inman, we said, insurance company, you don't have to pay out on the policy. We didn't say, though, to the applicant, or I don't remember if this was a death case or not, but to the claimant, we didn't say to the plaintiff, you don't have a negligence claim against the agent himself, right?
Your Honor, I would respectfully disagree only in the sense that I think that is what Inman fundamentally is about, that when the agent, in that case, the agent who was working for the insurance company, if they had committed negligence, then it would be, under agency principles, imposed on the insurance company, and there would have been coverage because the agent would have been liable, solely liable in that case, which is what's necessary to for the coverage to attach.
Just following up on that, isn't Elam versus Smithfield Realty Insurance Company from 1921 exactly the case that Justice Allen is asking for, but says that in fact you can sue the agent? That is generally held that where an insurance agent or broker undertakes to procure a policy of insurance for another, the law imposes upon him the duty in the exercise of reasonable care to perform the duty he has assumed.
Your Honor, yes, you can, for a policy, if you say, I would like to get a workers' compensation policy, and the agent doesn't get you a workers' compensation policy, and this is where you get into the Holmes case that was relied on by the dissent, the vacancy exclusion. I don't want a vacancy exclusion, and one's in there. The court has said, we are not going to impose liability on the applicant for failing to read the policy when it comes. But I think there's a fundamental difference between a policy and an application for insurance. With a policy that comes in the mail after you've applied that contains a vacancy exclusion or doesn't contain one, the court, I think, has allowed people not to have read those policies because they're long, they're complicated, they're not always easily understood. With an application, it is much more easily understood, and critically, the applicant themselves says, this is correct. I have read this, and there is no pond, there is no 5 acres. Now, if the applicant says, I don't want to read pages 1 and 2, I trust my insurance agent, I don't need to do it, that's fine. They're allowed to do that, but then they take on the responsibility or the liability for failing to do so.
Right. Well, and I have 2 questions following up on what you said. The first is, I mean, isn't what happened here in effect that the agent didn't get him a policy? Because if you apply for, if the agent fills in the information incorrectly in a material way, and then the insurer, there's effectively no policy there because the insurer doesn't have to cover anything because application didn't have the correct information. So it seems to me that this is like what you said earlier, that this is a situation where the agent, in effect, didn't get a policy for this person.
I think the court has drawn distinctions for the policy cases, as I'll call them, where you say, I don't want a vacancy exclusion, or I need workers' compensation coverage, and the agent doesn't honor those specific requests. The court has come to different conclusions when it is just generically, hey, we cited the Greenway case. Even though the agent knew that the people didn't have a phone and the policy provided a discount or lower limits for not having a phone, it was okay because that information was available and there wasn't a specific targeted request about the coverage. Every applicant that comes to an insurance agent is looking for coverage. If the exception would swallow the rule, if it was anybody that comes to an insurance agent and says, I would like coverage, and then if there's a material misrepresentation in the application, yes, every time there won't be coverage. That would mean but that's not what North Carolina jurisprudence has established, which is when you come to an agent, you say, I want this specific thing. If they don't get that specific thing, they can be liable. But if the reason they don't have that specific thing is because you made a material misrepresentation, that's a different circumstance.
But my second question is about, isn't what we're really wrestling with here is the reason, whether he was reasonably put off his guard. That's the line of cases, that the doctrine that we are interpreting in terms of what significance we put to the fact that he didn't read pages 1 and 2.
Yes, I think that is a critical piece of this case, is that whether he was put off his guard. And the problem is that there are no allegations in the amended complaint indicating that he was defrauded, that he was misled, that he was put off his guard, or that he was justifiably ignorant. All that is alleged is he was handed a signature page and that he wasn't handed the other ones, but that he trusted his agent would fill them out correctly. When he alleges that he trusted it would be filled out correctly, that's an acknowledgement that he knew either it wasn't filled out or that it had been filled out and he didn't need to read it. But either way, he is taking on the legal responsibility if there's an incorrect statement in the application. This is not to say...
But this is the part I'm struggling with. Why would there be any legal responsibility there when the fact that your client can be sued for something more than just the contract claim, which, of course, and I think that was, some of the older cases are the contract claim, which is why there was no contrib defense, but there is this sort of professional negligence claim. And so why isn't it that the person who hires an insurance agent, who has all these duties to act reasonably in making sure they place the policy, that if that person that's your agent, that you're paying them, they're going to make money off a deal, comes to you and says, here's a blank piece of paper, sign on the dotted line, that it's at least a fact question whether or not it's reasonable for you to say, well, I'm paying this person, they have the expertise, I'm going to sign, they obviously need me to sign it, and they'll handle everything else. Why shouldn't a jury decide, was that reasonable to do that or not?
Because we live in the great state of North Carolina with contributory negligence. One, Justice Dietz, the application wasn't blank. It said, I have read the above and it's true and accurate. If you flip it around, a lot of these arguments about what did the agent do wrong, maybe the agent did something wrong, marked the wrong box, knew or should have known that a different box should have been marked. That's one argument. And if that is successful, then under North Carolina law, you move from negligence to the question of contributory negligence. And then we look at the actions of Jones. And if you flip it around and if the agent had signed and said, this application is correct, here you go, Giovera, I don't think anyone would have a problem saying, yeah, the agent, that was potentially negligent. But when the applicant does it, I don't think it suddenly transforms into some different thing when just because there's a professional on one side, the applicant in theory knows more about the property they're insuring, and they are verifying what it is. It
But
also,
I guess what I'm getting at is if the facts are the opposite. So if the undisputed facts were that your client said, here's this form, you read it and do not sign it until you've read it because you know this better than me, so you've really got to be the one to check this. It would be a completely different case. But the point here is that in the relationship, the principal, because the principal has to pay the agent to perform something, and when you have a scenario where the law says we're actually going to impose a duty to act reasonably, it's not just the contract that's going to govern it, but your client has this duty of care, that it is reasonable for the person, the principal that hired the agent, to say, I'm going to assume that I have this trust and confidence in them when they tell me to do things. And there has to be some indication otherwise. And so at a minimum, it's a fact question. You've got to have the jury hear all this to figure out, was that reasonable or not? And we just can't say it as a matter of law on the pleadings here.
and Your Honor, I respectfully disagree. I think when the applicant puts his signature down and says, I've read this, this is right, that he then, at the minimum, is potentially his own negligence is at stake. The reverse of this solution or holding would be that every insurance agent has to not only get the applicant to buy into what they're saying, I've read it, it's true, but now we're saying they have to go behind them and verify each statement in the application, or else they're going to face liability. And it really doesn't matter that the applicant signed it and said, yeah, that's true. Maybe it matters at best, it matters for a jury question, but it's not going to matter for purposes of eliminating a case at the beginning, even though you've taken all the steps to say, look, I need your signature. I'm not just going to submit this on, if he had submitted it on his own, different case. But when he says the purpose of getting him to say, sign this, is to say, please make sure I did this right. And if I didn't, maybe I'm negligent. But if you're signing this, you're also in the boat with me, if you will.
But he didn't present pages 1 and 2. It seems to me that this would be a different case in that circumstance. But here he only gave him the 3rd page.
And that is what is alleged. But there is he impliedly in his allegation said, I trusted he would fill it out correctly, meaning he knew that there were more pages. He decided not to read them, ask for them, review them, even if his allegations are taken as true. So he doesn't get to say, I'm going to be willfully blind, and therefore I'm protected legally because I don't want to see these other pages.
Because it seems to me that the reverse is also true. That is to say that if the rule you're asking us to apply that as a matter of law, and contributory negligence is still a matter for the jury unless there's absolutely no factual dispute and no other possible conclusion that can be drawn. But here it would end up being that you could never place your trust in an agent, because you would always have to make sure that that everything they tell you, it would sort of mean there's no point in having an insurance agent. You really need to do it all yourself.
Again, I'd come back to the concept that the insurance agent could be negligent, and that could be a conclusion of this court in this case. But then we shift to the analysis of the contributory negligence, and we look at the actions of the applicant. It's not that you can never trust your agent. You can trust your agent, but if you sign and say this is right and I agree with it, and the agent did something wrong that you knew or should have known was wrong, i.e. details about your property. We're not talking about some obscure issue of insurance, but details about his own property. He said, this is right, that you have problems as well.
So what's wrong with this reasoning? If your client had a duty to include only truthful answers on the application, then it wasn't negligence on the part of the plaintiff to rely on your client to perform that duty.
I think the problem with that is the signature on the line that says, I've read the above and it is true and correct. That is the difference. That if he didn't adopt the application by his signature, I would agree with you. But he did adopt the information, and it's information he knew or should have known was incorrect.
Can it be contrived when you're relying on someone to do what they have a duty to perform?
Yes. I see I'm out of time for my rebuttal. I will note, because I'm supposed to bring up all the issues, punitive damages is also an issue in this case, and we've stated in our brief that no compensatory damages. There's no facts of fraud, willful, wanton conduct, or malice, and this is against an entity, and there are no allegations that the individual agent who allegedly made these mistakes, that their actions of willful and wanton conduct, the extreme nature of that, was condoned or supported by the agency or entity managers and such. Thank you, Your Honors.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. My name is Lamar Armstrong. I proud to represent the plaintiff in this case, Daniel Jones. I will note up front that the complaint that we're here to argue about refers to him as Daniel. To keep with court formalities, I'll refer to him as Mr. Jones or Jones, but we're talking about the same person. So the first sort of the low-hanging fruit here is that we plead in the complaint, and this is on record page 67, paragraph 77, that Mr. Jones signed a blank application. The application was blank when he signed the signature page. Hatcher disagrees with that, but of course that creates an issue of fact. Was it blank? Was there the rest of the application? Pages 1 and 2 refer to, did that even exist at that point, or was it blank?
Help me with that, because I have a hard time understanding how that is good for your client. Isn't there an argument that it's even more negligent to sign a document when you don't even have the application in front of you?
If the facts were that, Justice Allen, to your point, if the facts were as alleged, that there was just a signature page provided, nothing else said, no other representations, no assurances, just sign this document, then I still think it would be a jury issue, but then it would be a closer issue of contributory negligence as to, well, why didn't you ask for the rest of the application? The answer to that's in the complaint. The answer is because Hatcher gave my client specific assurances that all you need to do to obtain the same insurance that you already have, the same homeowner's insurance, is to sign this single page and to pay your first premium payment. In other words, all you have to do is these things, so you don't have to read the rest of the application, whether it's filled out or not. You don't have to go look behind and double check our work. This is all you have to do. And it's at least a jury issue to then be able to argue to a jury one day that that was good enough. Justice Earls, to your point, that was good enough to put my client, a regular average Joe person, off his guard to say, well, the expert in the room, my agent, is telling me this is all I have to do, so that's all I have to do.
And wouldn't the theory of signing something when it's blank, or you don't know what some other pages, there's more pages and you haven't looked at them, if that could be the sort of per se, just the fact that you did it, a breach of some duty, then in my wedding planning hypothetical, it would also be negligent to sign the blank check. And we know that sort of conduct happens all the time, and it's a very fact-intensive question about whether it was reasonable to do that or not.
Right. So to your analogy, Justice Dietz, the soon-to-be spouse signs the check, leaves the number blank, and then hands it to the wedding planner. The wedding planner, who incorrectly fills out the number, doesn't get to turn around and say, but you signed it. So you had some sort of ability to look in a crystal ball and know that at one point in time in the future, I'm going to put the wrong number in it.
Right. So it seems like the key distinguishing feature here is the language which your friend pointed to a number of times.
Yes. Right
Right above the signature that says, why am I signing this? Because I have read everything and it's accurate and so on and so forth. Sort of, there's some statement that you're approving as you sign it that was false at the time that the signature is made, that your client signed it. So what, in your view, how does that impact the analysis?
Sure. So the analysis there is okay, there's a statement below the signature saying, I've read and approved the above. That implies there was the above to read and approve. And so that creates a fact issue because we say, and we plead in the complaint, there is no above to read. There wasn't anything provided. There wasn't anything even available to provide. It was blank. They disagree with that, but then that goes to the point of, okay, you have a duty to read, and that sort of feeds into the contributory negligence analysis. But that just begs the question, duty to read what? And all of the case law that both sides have cited to in the brief and that the dissent relies on below assumes that there is something there to read, that if you were diligent enough, even if you had a duty to request the rest of the application to read, that it's there to read. For example, and there are 5 cases cited by the dissent, and I will note on this issue of contributory negligence, I will note that none of them are contributory negligence cases. In fact, only one of the 5 even mentions contributory negligence. That's the Baggett case where Judge Tyson wrote a dissent and it was adopted per curiam by this court. And Judge Tyson in that dissent describes the insured's duty to read as a duty to read based on a, quote, reasonable opportunity to read the instrument in question. That's North Carolina Reporter, page 53 of that opinion. This court's opinion in the Jones case cited by the dissent talks about how in that case there was no evidence that the insured was illiterate, was prevented from reading the contents of a contract or what was in it. Again, there's some sort of presumption there that there's some contents that are there to read.
But I'm back to my opening point.
Yes, sir.
If someone says, here's the contract, and I decide not to read it and I just sign it, okay, maybe that's negligence, maybe it's not. But if they say, here's the signature page, just sign it, we'll write the contract later. Why is that not a higher degree of negligence?
Well, if it's a commercial transaction at arm's length, maybe that's a point that can be argued. But here, my client's entitled to rely on his fiduciary agent when his agent tells him, this is all you got to do, trust me.
But I asked your opposing counsel near the end of his argument, can you have contrib when the plaintiff is relying on the defendant to do something the defendant has a duty to do? And he said yes, and clearly that's right, because that is the fact pattern in all kinds of negligence cases. So even if we say, yes, there was a duty on the part of Hatcher to fill out the application accurately, how does that absolve your client of the obligation to at least look at it when your client has signed a document attesting that he's done just that?
Well, a jury could one day decide, if it were so inclined based on the evidence, that despite the agent's assurances that he didn't need to do something, that he still did need to. But I still think that creates a jury issue when you have conflicting evidence and here allegations that the agent, who again is the expert in the scenario, effectively says you don't need to read the rest of the application. This is all you need to do. And so I think
So
that
just trust me.
Trust me, yes.
That's enough to avoid contrib.
It is enough. In fact, the Holmes case, relied upon heavily by the majority below, talks about that very issue. In that case, the insured was a sophisticated insured, not to say anything to the contrary to my client, but he was a commercial developer. He owned properties, multiple properties, and the fact in that case was that he had a prior claim on one of his properties that ended up getting denied because there was a vacancy exclusion. And the insurance company said, you know, your property there was vacant at the time of the loss. There's this vacancy exclusion. It's not going to be covered. And sometime after that, the insured goes back to his same agent and says, I don't ever want to have this problem again with vacancy. And no specific request, hey, make sure you reread my policies on all my properties, change the vacancy exclusion. I want to be covered for vacant properties too. But the court in that case still held that that was good enough to put him off his guard, even when the agent didn't turn around. There was no facts in that case that said that the agent gave him any assurances at all, that I'm going to do that. Gave him any assurances that, well, you don't need to read your policy to confirm that there's no vacancy exclusion. So even under those facts, that scenario in that case, the court said that's good enough to be put off your guard because you are entitled to rely on the expertise of your fiduciary agent. But here we have more than that. We have specific assurances that you don't need to go behind us to double check and triple check our work. Trust us, we will do this for you.
So what do we do with these cases like Inman, in which this court has said that when you signed the application, knowledge of its contents is imputed to you?
A couple things. Number one, there has to be contents that are imputed to you. So back to the point of the duty to read, there has to be contents that are available to read to be imputed with knowledge of those contents. And here we have well pled, that there are no contents to read. Number two, it's a factual question as to whether or not, to Justice Earls' point, whether or not Mr. Jones was put off his guard and therefore contributory negligence is a jury issue as to the specific assurances made by his agent. Number three, even if there is contributory negligence, and this is another point we've made in brief as well, that does not end the inquiry, because if the jury finds that Hatcher was grossly negligent, that trumps contributory negligence. And we have pled, contrary to the contention in brief, we have pled that Hatcher was grossly negligent in the complaint. In fact, you can find, this is record page 80, paragraph 206, and I'll read it for you. It says, in conscious and intentional disregard of and indifference to Jones's rights, Hatcher breached its duty to procure insurance against a designated risk. In conscious and intentional disregard of one's rights, that is the definition of gross negligence. So that was pled there, and that will be a jury issue, even if the jury believes, or even if this court finds that somehow as a matter of law there is contributory negligence. In fact, there's a pattern jury instruction that says exactly that gross negligence trumps contributory negligence. So there's multiple cuts at it, but at the end of the day, the 5 cases relied on by the dissent below, none of them hold that there is contributory negligence of an insured or an applicant as a matter of law on a motion to dismiss. In fact, as I said, 4 of the 5 don't even mention contributory negligence at all. It just delves into this issue of a duty to read, and even there, it's often summary judgment or triable issue of fact. Is there evidence sufficient to say that an insured had a duty to read or breached that duty or was put off his guard, so on and so forth. So really what Hatcher's doing here is they're saying, okay, you know, even if we accept as true, there's not a rest of the application that was given to him, which again, we're on 12b6, so we have to accept that well-pled allegation is true, that Jones had some sort of duty to go out and discover and seek out and find, is there a rest of the application? And if so, do I need to read it? So think about this. What Hatcher's really saying is that as a matter of law, on a motion to dismiss, my client had to go out on his own, search for errors and misrepresentations that he wasn't given any indication that he needed to do or that might exist, right? There's nothing in the complaint that says that Hatcher was put on, or excuse me, that Jones was put on notice that there might be some issue with the answers whenever they were filled out. But somehow he has to, as a matter of law, disregard what his agent is telling him, which is, don't worry about looking at the rest of it. Just trust us. Just sign this page. He has to disregard that as a matter of law and go and look behind the agent and look under all the rocks in search of what we don't exactly know, but still he's got this heightened duty to go out and seek out rather than just the duty to read what's reasonably available for him to read.
Well, in assessing whether or not he was reasonably put off his guard, it is intensely fact-specific, and don't we also have to take into account the facts of the prior course of dealings between this applicant and the agent, the fact that he knew the photographs were taken, that he had, as the applicant, he had every reason to believe that his agent had all the necessary information and correct information to successfully obtain insurance for him.
That's exactly right. Not only based upon the fact that Hatcher, through its history with Mr. Jones, had visited the property, taken the photos, had all the information in its file to answer the right questions. It just had to take the 1 minute of extra time it would have taken to check the file to make sure there is a pond on the property. Here's a photo that shows it. To look at it and say, oh, this property is more than 5 acres. It would have taken very little time to do that. So it's a fact-specific inquiry that is based on the history of the relationship. And then another thing that is not to be overlooked, the complaint goes through how this scenario of just being provided a signature page and that's all that he needed to do, that had already happened once before in their relationship. That happened before when Hatcher solicited and procured insurance for Jones on a prior policy. And that's developed in the complaint as well earlier on in the facts section. So this isn't just someone who has come off a street corner and said, here's a blank piece of paper, sign it without any sort of context. This isn't a Nigerian prince type of situation. This is something that's got history and has context, and that has to be taken into account, certainly on a 12b6. And we would say ultimately it's going to have to be decided by a jury. So this proposition that my client has a duty to seek out and discover, Hatcher's not provided a single case, a single citation that establishes that duty. It cites, and in fact, in our brief, we cite to the Harris versus Bingham case of this court. This is a 1940s case. It talks about the duty to read, and it cites the Williams case, which is even older than that. And that case talks about a duty to ascertain the contents of an application or a policy. And so they bold in their brief this word ascertain and sort of suggest that that word ascertain creates some duty beyond a duty to read what's put in front of you, but the duty to go out and seek and discover. But if you read the Harris case, it's clear from that case and the context of that case that read and ascertain are just treated as synonymous. It's just two different words that mean the same thing.
What if the theory is not so much the duty to read from those older, which seems to be mostly used against the insurance company by the policyholder who should have known what was in the actual policy? What if here it's a duty not to make a false statement? What your friend is saying is your client, it's undisputed that your client signed a form basically stating I'm lying because it said I've read something that the complaint itself says that your client never read. So, and that itself can be just sort of, it's negligence per se to make a false statement like that in this kind of an application, and that's the contrib. What's your response to that?
That may be a more meaningful fact if the case were between the applicant, the insured, and the insurance company. I believe, Justice Allen, you had questions about that earlier, but that's not the scenario that's before us. This isn't an insurance company arguing we get to rescind or deny coverage because you, the insured, made misrepresentations in an application, whether you knew about it or not. That's not the scenario that's before the court. And so, Giovera Insurance, whether they should or shouldn't have rescinded the policy, denied coverage, that's an issue that's not before the court. They've been dismissed from the case. The question is, now that they made that stand and made that decision, who's responsible for it between the insured and the agent? And there's not a single case out there, and certainly Hatcher hasn't pointed to any, that says that my client's duty extends so far as to basically suggest, as someone mentioned earlier, that in every single case, an insured has to distrust the agent's work and do its own independent review. I mean, can you imagine the policy that sets, regardless of whether this is an insurance agency situation or someone's consulting with an attorney or a doctor, and anything that's said, any statements given or commitments made, advice given, we can't trust any of that. We have to look behind the professional in the situation to figure out, are they doing their job or not, essentially. And that can't be the law. It's not the law. So I want to speak a little bit more on this issue of, the other thing in terms of this duty to discover, Hatcher does cite in their briefs, and it was mentioned by my friend here, the Thomas Yelverton Company case. And their argument there is that that case establishes that in a situation like this, where an insured signs an application, and then after that, the agent fills in the questions, that somehow the insured or the applicant adopts the yet-to-be-written questions as its own. That's not what that case says. In fact, that case dealt with a situation where the agent and the applicant sat down together, as often happens. Agent is asking applicant the questions, applicant's orally giving him the answers, and they're filling it out together. So that's not what that case says at all. And so this issue, moving on then about, okay, well, even if we assume that there could be some contributory negligence, was my client put off his guard? And the answer to that is yes, because there were specific assurances given. Again, the Holmes case here, relied on by the majority below, is instructive here because in that case, there was no specific assurances. When the insured says, there's this vacancy problem, I've already dealt with it once, I don't want to deal with it again, that's the extent of the conversation with the agent. The agent, at least reading the case, there's no fact that says that the agent turned around and said, well, let me assure you that I'm going to take care of this issue, that I'm going to take these following steps, so that you don't need to do anything else. All you need to do is whatever, sign a piece of paper or whatever. There's no fact of that. But even just that statement between the insured, who again, I emphasize is a sophisticated insured, and the agent in that case, was good enough to put the insured off his guard. Just by making that statement and the agent ostensibly doing something to act on it. Good enough to put the insured off his guard, and that was a summary judgment case. That wasn't a 12B6 case. The Heilig case, cited in our brief from this court, it's a slightly different scenario, but I think it's understanding the court's ruling there, it's hard to square with Hatcher's position here. So in that case, the court held that the agent's application answers done without the applicant's knowledge was binding on the insurer, on the insurance company, absent some sort of fraud or collusion between the applicant and the agent. And so in that case, the insured, the applicant, wasn't held responsible for an agent's answers in an application that the insured didn't know about, wasn't knowledgeable of. And so this court held that the insurance company can't deny coverage or rescind coverage on that basis. It's hard to square that with Hatcher's position here, that somehow my client should have done more to become knowledgeable about answers to an application that he did not know about and we contend could not have known about. A lot of these cases, to that point, do talk about, when it's exploring this duty to read, do talk about a duty to read an insurance policy. Well, here, even if Mr. Jones had sat down and read his policy, he couldn't have discovered Hatcher's misrepresentations in the application, right? The policy is just going to give you the policy terms. The policy is not going to talk about, here's the answers to applications that led to this policy. So there's nothing in the complaint, and this is really the bottom line. 12B6, we go by the face of the complaint. There's nothing in the complaint that suggests that Jones had any reason to distrust or be skeptical of Hatcher, go look under rocks, so on and so forth. Contributory negligence, applying the applicable standard, is not so clear on the face of the complaint that no other conclusion can be reasonably drawn therefrom. To the contrary, Jones was entirely reasonable in doing exactly what his insurance agent told him to do. I didn't hear any argument about Hatcher, whether or not Hatcher had a duty to procure. Again, we covered this in our brief. I don't think that's before this court because that wasn't a part of the basis of the dissent below. There was still argument about it in Hatcher's brief. I'm happy to answer any questions the justices have about that issue, but otherwise I will move on to the punitive damages issue.
Well, I do have another question. So I'm trying to determine what importance to give to the allegation that Hatcher had previously procured an insurance policy for Jones, why would that mean that Jones should trust him simply because he had obtained a prior policy? I could see the argument if Jones had to file a claim under that prior policy and it had been successful. But why does the fact that Hatcher previously procured a policy for Jones mean that Jones should assume that everything's accurate?
Certainly. So it's not the fact that Hatcher procured a policy before, it's the fact that the way Hatcher went about it with Jones before. The same way that it's pled here, which is before as now, here's all you have to do. Sign this signature page, we'll handle the rest. And so there's a prior, to use a terminology that just for analogy purposes, is there's a prior course of dealing there. There's an understanding that, okay, when Hatcher's saying now, here's all you have to do to obtain the same coverage, there's the context, there's facts that back that up, that tell Jones, in his mind, there's a reason I can trust what he's saying because we've already done this way before, and Hatcher's obtained coverage for me. So again, the statement's not made in a vacuum. I'm sorry, go ahead.
Yeah. So then was Jones negligent the first time?
No, because he trusted his agent. The agent ostensibly obtained homeowners insurance coverage for him before. And so he's entitled to at least make out to a jury that he can do it. He can trust his agent to do it again if he did it to him before.
So what I'm getting at is it seems like ultimately your position is if the agent tells you it's okay, you're not contributorily negligent.
Not as a matter of law on a 12b6. That's correct. Yes. So as far as this issue on discretionary review of punitive damages, there's two things here. The duty to plead punitive damages, Rule 9K, Civil Procedure Rule 9K, does talk about how you have to plead an aggravating factor with particularity, and we did that. The complaints in the record is 21 pages, 228 paragraphs. It pleads willfulness repeatedly. It says repeatedly, I don't have time, I was going to read the specific paragraphs, but it says repeatedly, and you can find them primarily on pages 79 and 80 of the record, that Hatcher knowingly misrepresented facts in an application. What is knowing? Knowing is willful. That's what willfulness is. It's knowing misconduct. So, and then that's done before, and then you go to the bottom of page 80, and that's where the beginning of the punitive damages claim is, which incorporates all the prior facts, including all of these allegations of knowing misconduct. So there has been...
One thing I want to ask about, because it seems to me if what we said is that all you need to do is sort of in a conclusory way use the word like knowingly, that's meeting the standard that's intended there, it would really kind of undermine the whole point of having a special pleading requirement. I mean, isn't a better argument that the facts that you've alleged provide the explanation of why it was knowing, which is that there's this financial incentive,
Yes.
which is you place the policy, that's how I get paid. So I know that this information may not be accurate, but I don't care because all I want to do as the insurance agent is place the policy and get my money. And that's the reason why you can get to the requirements that would allow you to assert the punitive damages claim.
That's correct. It's the underlying facts that are pled that lead to an inference that if those facts are proven true, that was knowing misconduct or willfulness. That's what you have to do, and that's what Rule 9K means when it says plead an aggravating factor with particularity.
So in sort of a mine run negligence case or just some med mal case, you
Yeah.
can't just stick the word knowing in front of every time that you say the physician did whatever it was that was this breach of the standard of care, and voila, you have a punitive claim. The point is here, you have the theory of what makes this a tort claim, a negligence claim that gets you punitives as well.
Correct, and to that point, I mean, Rule 9J, we're all familiar with, does have, okay, here's specific requirements when you plead particularity in a med mal context. That doesn't exist in 9K. 9K just says plead the aggravating factor with particularity. So we think we've done that. The other issue with the punitive damages quickly is that Hatcher's incorrect that my client had to specifically say in his complaint that Hatcher's officer, director, or manager participated in or condoned the aggravating factor. And there's nothing in Rule 9K that says that. Rule 9B of the Rules of Civil Procedure say that you can plead state of mind generally, not specifically. And it would just create a really bad policy to, in every single case where a plaintiff is suing a corporate defendant, some sort of entity for punitive damages, that you have to include these magic words. Because the policy is one of notice pleading, right? Which is, you just want to make sure that the defendant is on a basic level aware of what he or she, or it in this case, is being accused of doing wrong. Hatcher's not going to ever show up in court one day and say, well, I didn't know that your theory of punitive damages was that someone who had authority to act on our behalf acted on our behalf. That's pretty well implied when you read all the pages of the complaint and it says Hatcher knowingly did this, Hatcher willfully did that. It's well assumed, and we cite the 1D-15 statute of punitive damages, which says that's what you have to do ultimately to recover against an entity. 1D-15 doesn't say you have to plead any of these things. It just says you have to prove them at trial. And so, again, at this early stage, we would submit that that's all you have to do, and it would create negative unintended consequences if you created this additional pleading requirement on the 12B6 stage. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. Couple quick points. As far as the argument that there was a blank application and had to look under rocks, it's hyperbole. All he had to do was say, hey, where's the rest of the policy? I'd like to read pages 1 and 2 of 3. So this is not some Herculean effort. Talks about that my client should have taken the extra minute to check their file for pictures. Mr. Jones could have taken the extra minute to say, where is the application? And if he had done that and my client said, oh no, I'm not showing it to you, we're in a very different case. There was arguments about the Holmes case. Holmes case is about an insurance policy, not an application. So when you say, I don't want a vacancy exclusion, you can expect that there won't be one in the policy. It's a very different case if in that case, if the applicant said, I don't want a vacancy policy, the agent mistakenly said, it is vacant or it's not vacant, and then the applicant signs and says, this is true. Because the applicant is then taking on, despite what he said earlier, despite whatever he promised earlier, that it is vacant or it is not vacant, or however that is expressed, he is then saying this is true, because circumstances can change and the insurance agent doesn't have to go behind the applicant and say, now, I got to independently verify that. They have to be able to trust what the applicant is attesting to. As far as the law that allows for this legal principle, it's all those cases that say when you sign something, you are imputed, the knowledge of what's in the document is imputed to you. That is the information that was available to Mr. Jones because he had the ability to read the application. If he had asked about it, if he had wanted to see it, and there are no allegations he was prevented from seeing it. There is an allegation it wasn't provided to him, but not that he was prevented from seeing it.
Can you address the argument that the plaintiff has alleged gross negligence or something higher than that that defeats contrib?
Yes, I disagree that it was pled. There is no cause of action entitled gross negligence. He accurately read his paragraph from the negligence section. The Court of Appeals did not address any arguments as to gross negligence. The trial court didn't address gross negligence. The trial court found on behalf of contributory negligence, and therefore would have, because he's correct on the law, they would have had to have addressed gross negligence if they were basing their decision on contrib. The dissent didn't address it because it concluded that there's contrib and didn't do any further analysis. So this issue wasn't raised.
But if he pled, if we agree that he pled sufficiently to allege entitlement to punitive damages, doesn't that mean he pled at least gross negligence, if not intentional misconduct?
I think even with notice pleading, there has to be some sufficient notice. And when you have a section for punitive damages and then try and bootstrap that into an earlier negligence section and say, well, I really meant that was gross negligence, even though I used the terms negligence the entire time, I think that puts defendants off. But even if we get there, then you have to examine the facts of the case. And the facts of the case are allegedly that my client presented a signature page and filled out an application, arguably incorrectly, but that's what he did.
Well, but the allegations in the complaint, and they may not be able to prove them, but the allegations are, and particularly with respect to punitive damages, that he intentionally misrepresented facts about this property so that he could get the insurance policy placed, and that seems to me to be sufficient to overcome contributory negligence.
And respectfully, I understand the allegation they use. He uses words like intentionally or knowingly to try and do that. But the facts, other than the magic words used, the facts are that this application was filled out when he knew or should have known that there was a pond on the policy and just checked no. There is no indication that he would have known that that would be determined to be a material misrepresentation, or that would have canceled the policy, or that would have prevented coverage from existing. As you recall, the pleadings are that there was coverage. It was just rescinded for the material misrepresentation.
Thank you, counsel. I believe your time's expired.
All right.